Open up the public hearing and hear from the prime sponsor, Representative Cole. Good morning, Representative Cole.
Good morning, Mr. Chairman and members of the Commerce Committee. HB 733 FN. All right, this is new legislation. We haven't seen it before up here at the State House. This is something that's going across the states here in the U.S., so let's get into it. What is TPLF, or third-party litigation financing? It is when an investor helps finance a lawsuit in which the investor has no personal stake. At the moment, parties involved in TPLF agreements are not required to disclose these actions. So defendants in courts do not know the presence or identity of the funders as real parties with financial interest in the case. Lenders who engage in TPLF are largely unregulated, and as a result, TPLF attracts hedge funds to participate in litigation financiers because the industry is not subject to the same limitations and regulatory oversight as normal consumer loans. This avoids critical consumer protection oversights, which is why the bill landed in this committee. It also attracts outside financiers such as foreign entities influencing lawsuits. Do you want to take a look at the law on page number 3? Or the bill, I should say. I want to point out lines 9 through 28, and that's dealing with the foreign entities. I know Representative Spear had a question about the governor, and that's where it lands in this bill. That's just part of the definition. Yep.
Since you're looking right at me. I know what it is, and
We're not taking questions.
oh, okay.
Let him finish his
Stop looking at
testimony.
me.
All right. Litigation abuse is a notable factor causing an upward pressure on insurance costs, and it's only getting worse across the country and right here in New Hampshire. This is known as a tort tax, okay? I'm sure someone behind me can explain a tort tax much better than I can. They could be more eloquent about it. But it's basically causing upward pressures of 15 to 20% in the lawsuits. One way the states have begun to combat such abuse is through the TPLF transparency laws. I've attached a list of these states to the packet that I handed out to you that have already passed laws or the court rules as part of my testimony. So working with Ms. Nato and Mr. Lapine, we decided to base our legislation on the NCOIL model that was released late last year. So that's what this whole bill is modeled after. TPLF is estimated to be a 400 billion with a B, global industry. It's essentially turning our civil justice system into another commodity for investors to make exorbitant profits. To ensure a high rate of return on its investment, the funder seeks to increase the likelihood of a trial, thus enhancing the possibility of frivolous and misguided litigation. By turning the civil justice system into a money-making machine, TPLF discourages amicable settlements of disputes and instead encourages aggressive and prolonged litigation of marginal or frivolous claims. This again adds to the state's already significant tort tax on households. It drives up the cost of products, services, and insurance. States have started to enact TPLF transparency laws to protect the fair and efficient administration of justice. This includes legislation that requires common sense guardrails around the use of TPLF, including funding prohibitions. So again, if I can ask you to turn to page number 6 in the law, or the bill as written. Page number 6, lines 20 through 37, and then on to page 7 all the way through 26. That's dealing with all those guardrails that we're putting in for consumer protection. Okay? You can go over those afterwards. And then the mandatory disclosure of the TPLF agreements are on page number 9. So if you want to take a quick look at page number 9, just point those out to you real quickly as well. That's on lines 10 through 17. There's only 3 reporting requirements. It's not an exorbitant thing that we're asking to be done here. Okay? Discoverability of these arrangements and lawsuits and state-level regulation of funders is the main purpose of this bill. By requiring disclosure of TPLF to parties in litigation and the courts, balance can be restored to the legal system, and the related increased product, service, and insurance costs associated with this will be reduced. That's my testimony. Now I have two things that we need to do a little house cleaning on this. Attorney Schuler brought it up to my attention. So we need to add a word knowingly at the very end, and we left out a section that we had originally in there. I sent you this one page. I gave it all to you, this one page. So this needs to be incorporated in the bill at a later date, but he understands that we are going to put it into the bill. And with that, I'll take any questions if you have any.
Okay, Representative Spear.
Thank you. So getting to what we were talking about.
Mhm.
I know what the CFR 791 is, and I know the countries that are in it.
Mhm.
And they're kind of like known around. But I looked at the Constitution, and I can't find any place in the Constitution that says the governor has the right to declare another country to be a threat to our infrastructure. So where are we getting that from?
I don't know it's another country. I think it's more of an entity or an entity from another country. Although in here it says country.
Or a country designated as a threat to critical infrastructure. And what criteria would they use, and where do they get the right to do that? And it's not in the New Hampshire Constitution that they have the right to do that. So I would like you to look at that a little bit.
Okay. We can look at that. I'll have the lawyers look at that too.
Yeah.
So where is that?
Page, on the new bill, on the new amendments, page 3, around lines 7 and 8, 9.
It's on page 3, lines 10 and 11. Of a code of federal regulations or a country designated as a threat to critical infrastructure by the governor by written notice of the Department of Safety. So I think it's the Department of Safety that's making that determination and
So this
passing it
is
on.
under
to
He
the
writes the
governor.
notice
This is
to
under
the,
definition?
This is under definitions, yeah.
but then but throughout the document, it calls out a person or country of concern. And the definition of a person or country of concern is somebody designated by the governor, among other things.
Okay, so who should be someone who decides that it, rather than the
I have
governor?
no problem with CFR 791, but I don't think the governor has any right to say or even knows who is a threat, what country is a threat to our infrastructure.
Okay, gotcha. Yeah, all right. So was that in the original NCOIL
Yeah, it was-
legislation?
Oh,
Yes.
Okay, well, I'm sure they have a good reason for it. All right. Any other questions? Yet another one, different one.
all right. Now getting to the CFR 791, China's of course on that list.
Mm-hmm.
I think it's something like 20% of our lumber, it's certainly our hardwood lumber in upstate, goes to wholesalers and distributors in China. Does this mean, your interpretation, since you've been with this a lot longer than I have, does this mean that we can default on a delivery and they cannot sue to get their delivery by contract? For instance, supposing some third party in China wants to back up, we don't deliver.
Mm-hmm.
They paid for it, we didn't deliver.
Yeah.
Now there's a lawsuit between these two people, and they hire a third party to help fund that lawsuit. Does that mean that they cannot do that?
That third party would have to report. And if they're on this list, no, they wouldn't be able to do that.
They wouldn't be able to do it.
Right.
So
But
China
these
is free to
these
get-
are outside entities influencing lawsuits, right? They have no interest in the lawsuit other than monetary gain. That's what this bill is aiming for.
Okay, so the Chinese receiver of the lumber still could sue to get their lumber.
Yeah, but they can have a third party financing it, according to this.
Well, the question would be is, would they have solvency issues or financial issues that would need them to find a third party
Right.
to
Yeah.
That's
finance
the
it?
question. That's the question. And you're
Right,
saying,
and so
no,
what
they
we're
would not be
saying
allowed.
is, if it's a foreign trade, you're all bets off. That the ability to do this financing is really only American citizens. We only want Americans to be able to get this, because really it's more aimed at an actual citizen, not even for a small corporation. We assume corporations know what they're doing and know how to handle their litigation expenses. Would you believe?
Would you believe?
Okay. Any other questions? Oh, yes, Representative Sullivan.
So, sorry, I'm not as prepared as I should be because I didn't get this. I didn't get to read this before I came in. But is this essentially saying that if I were to be in a lawsuit, I couldn't get funding or financing to help pay for the expense of that lawsuit by somebody who isn't party to the lawsuit?
That is not saying this at all.
Okay.
This is a reporting measure.
Oh, it's purely about reporting.
That's right. We're not saying that the activity cannot occur.
Okay.
We just want to know who's doing it and to what extent.
Okay. So if I found some outside investor who thought, "Oh, I'm going to get a share of your windfall if you win,"
Have at it.
I can do that, and then but that has to be disclosed that this company is okay.
Correct.
And isn't it true that some states actually did try to cap that contract and how much you could get, but that is not in this bill?
Yes, that was a
In New Hampshire,
consideration.
it's a live free or die.
Yeah.
Okay, thank you very much.
Thank you.
All right, Brandon, because I know you're a busy man, so I want to have you come up right away and let us know what your concerns are. Garad. Good morning.
Good morning, Mr. Chairperson, members of the committee. My name is Brandon Garrett. I'm a Senior Assistant Attorney General and Chief of the Consumer Protection and Antitrust Bureau at the New Hampshire Department of Justice. Here neither in support nor against this bill, nor with any opinion on whether it's needed or the merits, but simply to point out that I believe the enforcement provisions that have been built into this, which anticipate Attorney General enforcement, perhaps are not as well thought out as they should be, and don't actually provide meaningful opportunity for the Attorney General's office to be able to prevent, to enforce and hold accountable those who might violate this. And currently, if I am reading it correctly, there is an enforcement provision for the Attorney General's office that is built in, looks like on page 8, 294F7B. A consumer litigating funding company that violates any provision of this chapter in a specific funding case B shall be liable for a civil penalty of not more than the fines established in RSA 358C4 for each violation, which shall accrue to the state and may be recovered in a legal claim brought by the Attorney General. So that gives us the ability to pursue a civil penalty and to do nothing else. So ordinarily, we would have all the rights and remedies available under the Consumer Protection Act, including the ability to go to court to enjoin the conduct and protect people from further harm. This simply gives us the ability to pursue a penalty, and if what we're talking about is a $400 billion operation, as was described by the sponsor, I would suggest that a $10,000 penalty is probably going to be written into the cost of doing business and won't pose much of a real threat to anybody who wants to completely ignore this and challenge the Attorney General's office to come get them with a fine. Happy to enforce this bill if it was put into law. However, I think that, anytime the Attorney General's office is given an enforcement responsibility, it's important to give us broad authority to take measures that are appropriate to not only fine a business, but to prevent the conduct from harming anybody in the future if they're ignoring state law. And I think that the way this is written, we may not have that opportunity. So I wanted to be sure to point that out and to pose for your consideration that, if the Attorney General is going to be enforcing this and holding companies accountable to the requirements that are baked into this bill, we should have all the rights and remedies available under 358A in order to enjoin that conduct, seek restitution, investigate, not just merely the ability to bring a claim for a civil penalty.
Well, notwithstanding that, we're talking about could potentially assurance product, and insurance is technically exempt for the Consumer Protection Act. So wouldn't we have to then cover that shortcoming also?
Potentially. I know that there are a number of folks here from the insurance department who I think could speak to whether this is or is not an insurance product and in what context it would or wouldn't be. I admittedly know where that line is sometimes, but not all the time. So all I can speak to is there is built into this a expectation that the Attorney General's office will be able to get civil penalties. There could be an exemption issue in there as well, but even if there isn't, I don't think that this is going to provide the AG's office with the meaningful opportunity to do anything about violations of this statute.
So how about we just lift the penalty, not make any reference to 358A, but just lift the penalty of triple damages, which is a right of private right of action, and just leave it as a private right of action rather than getting the AG's office involved at all.
That is certainly up to this committee if that's the track that you want to take. I would leave it to my colleagues at the insurance department to speak to whether they would have any meaningful enforcement over this. Certainly, if what you're trying to regulate is a business that is using a product that is ripe for consumer protection violations, which it seems that this would be, I would imagine you would want at least one state agency with the ability to meaningfully enforce it. So I can't speak to whether the insurance department would be able to do that. As it's worded, I don't think the Attorney General's office would be able to do it.
Right. Okay. So we just need to move it out of the 358A and put it into the consumer protection statutes in the insurance department, if the insurance department wants it.
Well, there's the question of want, and there's also the question of whether
It's
it
appropriate.
always would be an insurance product over which they would have the authority. Certainly, if it is, then they would. If it isn't, then we would, if it's an unfair, deceptive act or practice, which currently it isn't. It just gives us the ability to seek a civil penalty. So I think all of those considerations are the points that I wanted the committee to take away from my testimony. Happy to answer any questions if I can be helpful.
Perfect.
Thank you.
Thank you very much. Okay. Call up DJ Betancourt from the New Hampshire Insurance Department.
Good morning, Mr. Chairman, members of the committee. For the record, DJ Betancourt, Commissioner of the New Hampshire Insurance Department. You guys have put my law school education to the test here this morning, thinking through some of these issues. I'll focus on the insurance pieces first, but I have nothing to say on international law, so I'll disclose that at the outset. What brings the department here today, and I've talked to you about this on a number of occasions already, and I won't get into it, but we've talked about the current hard market that the industry is going through. And I think, as I've mentioned before, some of the industries that are most impacted by the current hard market are nonprofits, and just recently has come onto my radar, daycare centers and childcare centers. They are really struggling. Those nonprofits and those daycare/childcare centers are having a very, very difficult time finding liability insurance. And where they can find it, it is enormously expensive because, as I've said, there's a basic supply-demand type dynamic that sets in, that the narrower the access to coverage, the more expensive the coverage that remains becomes. And as you look at the components of that hard market, and again, I've talked about this before, but social inflation is one of the drivers of that hard market. And so we look at this legislation as having the potential to play a significant role in softening the hard insurance market in a handful of ways. The first is with enhanced risk transparency. And so by disclosing litigation data, insurers gain clearer insights into the risks associated with specific sectors or types of coverage. This transparency helps them better evaluate and price policies, which can potentially lead to more competitive premiums. The second is improved market competition. When litigation data is readily available, it allows insurers to identify areas of opportunity or underpricing in the market. This can lead to increased competition amongst insurers to offer better rates and coverage options, which again can alleviate the pressures of a hard market. Third, informed underwriting decisions. Access to third-party litigation information aids insurers in making past litigation outcomes, access to third-party litigation information aids insurers in making more informed underwriting decisions. By understanding past litigation outcomes, insurers can adjust their risk assessments and policy terms, which can lead to more favorable conditions for policyholders. Fourth, encouragement of innovative solutions. With a clearer picture of litigation trends, insurers may be encouraged to develop innovative products or services that address specific risks. This creativity can lead to more options for consumers, can help increase competition, and help stabilize the market. Fifth, better claims management. Transparency in litigation can improve claims management processes, allowing insurers to identify common issues that lead to disputes. By proactively addressing those issues, insurers can reduce claims costs and enhance their overall profitability, which in turn can lead to more favorable market conditions and lower premiums for consumers. So, in summary, Mr. Chairman, the disclosure that is contemplated in this legislation helps insurers meet their regulatory requirements as well as the other items that I've listed there, and the transparency can help maintain the overall health of the insurance market by ensuring that companies are accurately representing their risk exposure. The disclosure of third-party litigation can enhance transparency, support better risk assessment and management, foster competition, and ultimately lead to a more efficient and stable insurance market. Before I conclude, I would just note that we deal oftentimes with model legislation. The model legislation that we most commonly deal with are typically model laws or rules that come from the National Association of Insurance Commissioners. We don't see as many from NCOIL, which stands for the National Council of Insurance Legislators. But my experience has been that while there is a lot of stakeholder input, there's a lot of vetting that goes into these model laws, and most of the time they take years to develop, to work through all of those issues and to ensure that all of the stakeholders have had an opportunity to share their feedback. You have to have a certain level of flexibility within the models to account for the various nuances that each state is going to have to account for. So the fact that there are some language considerations that probably need to get worked out during the subcommittee is hardly a surprise. With respect to the issues that the Attorney General's office raised, I'm a bit skeptical that we'll have authority there. This is a financial type product and not one that we would typically oversee. So I'm not sure that the entities identified in his testimony are ones that we regulate, but we can certainly have a conversation that pulls in not only the Attorney General's office and my office, but probably banking as well, to make sure that we're getting that exactly correct. Banking, along with insurance, has our own ability to enforce the Consumer Protection Act that is outside of the authority of the Attorney General's office. So that's why we'll need to bring those three parties together to figure out exactly, as Mr. Garrard identified, where the lines of authority are so that we can collectively make sure that we're getting this legislation where it needs to be. So with that said, Mr. Chairman, I'm happy to take any questions.
I guess I forgot to ask Brian. Who's the reporting to? Who in the transparency of this, where they're reporting it? Who are they reporting it? What is it? Secretary of State's office?
Yeah.
Secretary of State's
Yep.
office. Mhm. Okay. And then, but at this point, you don't see this as technically you're being regulated by you anyways.
It's not clear to me that
Right.
we would be the ones that
So,
would
so
handle the
theoretically,
enforcement.
because this is in, would you believe that this is really, I guess, something that's going to be handled, the penalty is but through a litigation, then the penalties really should just be the triple damages, just the phrase, the triple damages, and let the court handle the case, complaint in court, and keep it out of insurance and banking altogether.
Mr. Chairman, if you believe it, I believe it. That's certainly an option.
Well, I'll see what I believe after the hearing. Thank you very much.
You betcha. Thank you,
So,
Mr. Chairman.
Now let's see what I really believe. Let's have Marissa Chase and Samantha Heving from the trial lawyers who are in opposition to this legislation. Just happened to not be in the room when I said, "Is there anybody in opposition?" But I'm glad you're here, so we do get the other point of view, which I love to have.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Marissa Chase. I'm the Executive Director for the New Hampshire Trial Lawyers Association, the Plaintiffs Bar. And with me is Samantha Hearing from the law firm of Shaheen and Gordon. She's a member of our board. I just want to start out with This is as we've heard, this is a national model piece of legislation. I believe it's well intended. This is very biased and one-sided. This only seeks for disclosure on the plaintiff side. There are no similar financial disclosures meant on or in this legislation placed on the defense side. If this were really about transparency, I think we would ask the insurance companies to disclose how much they're setting aside in reserves to settle any single.
Oh, we've heard
Case.
that issue before, huh?
We have, Mr. Chairman. We've been through this dance before. And I will
But
also,
this is the opposite side of the dance, right?
no, I think it's the same thing.
Okay.
But, and before Attorney Hearing gets into her testimony, I will just note that, New Hampshire's a small state with a collegial bar. Our members do not recommend generally for plaintiffs to seek litigation funding. We are not, we don't believe that we believe they often do not serve the best interests of the claimants. This is a small state. We're not a state that sees massive torts or massive class action lawsuits. This type of advanced funding litigation typically happens elsewhere in the country. Thankfully, not in New Hampshire. We don't have to burden ourselves with that. So we believe this bill is unnecessary, and already any concerns that this seeks to address are already covered by court rules, not by implementing a new statute. That I was looking at RSA 294, and this is to govern disclosure in court procedure. This seems like a weird place to put it. So with that, I will turn it over to Samantha, if that's okay.
Thank you. And I would echo what Marissa said about our general policy, and I shouldn't say policy, our general rule of thumb as attorneys who practice with the trial lawyers group is that we strongly encourage our clients not to seek these contracts. I tell people something to the effect of, it is your money, and it's not my place to tell you what to do with it, but I want you to be aware of these really high interest rates and how over time the amounts can build. That's certainly something that a lawyer should be counseling their clients about, but I don't see that the disclosure requirements of this bill, in terms of disclosure to litigation parties, not the terms of what should be disclosed in a contract to the consumer, but the disclosure provisions in this bill regarding disclosure to parties of litigation don't do anything that I can see to advance the claimant's interests or protect the client in any way. New Hampshire already has a sufficient system of mechanisms in our court rules to make sure that parties are giving the other side all relevant information in discovery. We start with Rule 22, automatic disclosures in every case, where within 30 to 60 days of pleadings being filed at the beginning of the case, parties have to give certain information to each side. List of people with relevant information, a copy of all documents that are relevant, a couple other things. Now, of course, you don't have to trust that your opposing attorney is going to give you everything that's relevant. You can still seek discovery under Rule 21 from the court. And that rule sets out various methods in Part A, I believe. If I were to seek discovery from my opponent and they were to improperly fail to respond or respond with an objection that just truly has no merit, I can go to the court, I can seek a motion for conditional default, I can also seek a motion to compel to force them to give me that information. And in that process, what the judge does, as many of you probably know, I'm sure, is they apply our test to determine whether evidence is relevant. Under Rule 401, evidence is relevant only if it has a tendency to make any fact of consequence in the action more or less probable than without the information. Fact of consequence is an element of the claim or the defenses, or even damages, but it's certainly not the existence of a funding contract. The other point that I would make is regarding the privileged communications provision, which is under 294F10, excuse me, 294F9. That makes the communications between the consumer's attorney and the funding company privileged only with respect to the person against whom the legal claim is asserted. But it does not mirror the language of the disclosure provision, which says that consumers have to provide that to parties that they file the claim against, parties to litigation, or any insured with an obligation to insure the claim that's being litigated. So I think those communications should be privileged from start to finish. But I just want to echo that in a system where we often defer to judges and courts to determine issues of relevance, admissibility, who should get what documents in a case, what does the case actually need, I think that we should continue doing that. Sometimes we lawyers like to fight for no reason, and the judges can resolve that very quickly. Also, I think if transparency is the goal, I think we can establish that very well for everybody involved by having a judge do, for example, in-camera review of any relevant documents before deciding whether that's disclosed to the other party. Happy to take questions.
Okay. Any questions from the committee members? Yes, Representative Baselli.
Thank you for letting me ask a question. Thank you for your testimony. Do you happen to know currently if there are any third-party litigation financing agreements currently in New Hampshire with any cases?
Yes, I do. I know that it's come up in the context of the YDC cases, which I'm sure everybody here knows about. Some attorneys who took over later in the process, once those cases had already become, they'd already started, they were already maybe halfway through or so, attorneys who took over later, what we realized was funding contracts were already well established for those cases, and the train had pretty much left the station. So in that circumstance, we do have to sign the contracts on occasion, but that's the only context I'm aware of that it's actually come up.
Okay, thank you very much. Okay, Nat Grays from the BIA.
Thank you, Mr. Chair. Nate Grays for the Business and Industry Association, Statewide Chamber of Commerce. We support this legislation. I will be as brief as possible. I think the 5 reasons listed by Commissioner Betancourt are some of the main reasons that we support this legislation. So I'm not going to repeat those. I do want to address one particular thing here. This issue was brought to our attention by the U.S. Chamber as an emerging issue. New Hampshire, despite being a small state, has become increasingly attractive as a place to see this type of funding, simply because the industry, as the sponsor mentioned in his opening statement, is growing. So they're looking for new markets. We also have cases like YDC that are attracting this type of investment. And other states are enacting transparency laws as well, which is encouraging the market to adjust and to move into states like ours that don't yet have this type of transparency legislation. Because we don't have it in place, we really can't accurately judge how much of this is occurring in the state. And we think that this is really important for the process that I outlined in my letter, which is really so that the parties to litigation and the court system understand what's happening. They understand the different dynamics that are occurring, and they can make reasoned judgments within the context of the case. Certainly happy to take any questions anyone may have. And I'm happy to work further with anyone on the subcommittee on this.
Okay, guess we don't have any questions.
Thank you.
Cam and Lindsay from Orrin Reno. We have Cam.
Yes, Cam.
Good morning, Mr. Chairman, members of the committee. For the record, I am Cam Lapine. I work at Orr and Reno. I am here today representing the American Property Casualty Insurance Association and the New Hampshire Association of Domestic Insurance Companies. We are in support of this bill. I will be as brief as I can. The prime sponsor and those who spoke before me did fantastic jobs presenting the bill. This practice of an uninterested party coming into a lawsuit to provide for solely financial reasons dates back hundreds of years, and it was illegal under English common law for hundreds of years under the practice called champerty and maintenance. It was not until the 1990s, it's my understanding, and I'm not an attorney, let me begin with that. It's my understanding in the 1990s in Australia, where the modern practice of third-party litigation financing began, and it has swollen to, as the prime sponsor testified, a $400 billion global industry. This, as others have said, is a very unclear, unregulated, shadowy industry. The impetus for this bill, House Bill 733, came about over this last summer and fall. There was a study committee, Senate Bill 236, which I was the staff member of that study committee before I entered this role when I worked for the Senate. And one of the things that committee, it was a study committee about the hard insurance market for nonprofits. And one of the things that came up in that committee was nuclear verdicts, the incredibly high costs that insurance has to pay, and nonprofits being pulled into lawsuits that they have there was no legitimate reason for them to be brought in other than seeking another pot of money to get. So that's where this bill came from. I'm just checking my notes here to make sure I didn't miss anything. I think that is everything I want to add. I'd be happy to take any questions if there are any.
Representative Ammon.
Thank you, Mr. Chair. Thank you for your testimony. You described the shadowy industry, and I'm just wondering, how does that work? How do they determine which cases they're going to pursue to sort of reinforce so that they can share in the rewards? How does that work in your understanding?
Sure. So my understanding, thank you for the question. My understanding is that they look well, first off, we don't know how often or how many of these cases there are because there is no disclosure or transparency unless you're in one of the states that has enacted or the court district that have enacted disclosure rules. My understanding is that they're just looking for the biggest pot of money that they can get and support those cases to bring in that money.
All set? Everybody all set? All right. Thank you. Eric Schuler? Opposes the bill as is. Okay, there we go. You would like to see it amended?
Qualified.
Yes.
Qualified.
Okay. Who is ARC?
Good morning, Mr. Chairman. My name is Eric Schuler. I'm the president for the Alliance for Responsible Consumer Legal Funding. It's easier just to put ARC. That's our kind of what we go by.
Say it again.
The Alliance for Responsible Consumer Legal Funding. We're the trade association, largest trade association that represents the companies that offer the consumer legal funding product. First of all, I want to thank Representative Cole. When this bill first came out, he was very receptive to meeting with me and with the other interested parties and trying to work out a bill that I think with the amendment we're pretty much in agreement to. It's kind of nice to see everybody on the same side as opposed to everybody yelling at each other across the table. So I want to thank him for allowing me to come in and make some suggestions to the bill, and which in the amendment is the suggestions that we put forward to it. One of the things I think I just wanted to kind of maybe take a half step backwards and clarify is there's two products that fall under the term of TPLF. One of which is consumer legal funding, and the other was litigation financing. And they're two different animals, but they get lumped in under one umbrella. So what litigation financing is, it is just that. It finances the litigation. The money is used specifically for attorney's fees, deposition costs, making sure the court filing fees are covered, all things like that. Consumer legal funding is where a company gives a consumer who has a pending legal claim, in most cases they're car accidents, some money for immediate household needs, mortgage, car payment, things like that. And we're clear the funds we provide the consumer cannot be used to fund the litigation. To give you some differences, our average funding on the consumer side is about $3,000 to $5,000. The minimums on the litigation financing side start at $3 million. It's just a couple of zeros difference. I gave testimony in another state, and one of the legislators told me, well, it's a government rounding error, but that's another story. And what I really like what Representative Cole did was we clearly defined the two products in the new draft of the legislation. We recorded differently the consumer side of things and what I call the commercial side of things. So you're regulating properly the consumer legal funding, the consumers who get money to make sure they can keep a roof over their head and food on the table, and also addressing directly the differences on the litigation financing side of those entities that give money to fund the actual litigation itself. When the phrase came up, this is a $400 billion a year industry. I want to clarify, that's on the litigation financing side. That's not on the consumer legal funding side. Trust me, if we're a $400 billion a year industry, I'd be asking for one heck of a raise. We do some work in New Hampshire. I've did some checking, and I think we probably do about 150 to 200 transactions a year. So on the consumer legal funding side, it's not a huge market, but I'd like to have 50 statutes, 50 states. I want to make sure that the consumers who are getting the consumer legal funding product are getting it from responsible companies, getting it from companies that are doing it the right way. It also actually helps my companies, because if you're doing work, especially in the financial services end, in an area that's unregulated, you could have one court order, you could have one decision come down, and it could wipe out your entire portfolio. By having guardrails on it, you're ensuring that what you're doing is doing it properly, the consumer is protected, and the legal system itself is also protected. So with that, I'll be happy to answer any questions.
Are you regulated by anybody?
In certain states, we are, yes.
Under insurance?
Well, it depends upon the state. So in
Okay.
some states, it's a registration with Secretary of State's office, which I think is kind of looking at here. In some states, it's Department of Consumer Credit. In other states, it's Department of Banking. It's whatever that particular state has. In Ohio, as an example, it's basically a thou shalt and thou shalt not type of a thing. There isn't a registration or a regulator there. If you're interested, you can go to our website, which is on the portfolio on the right-hand side. You can see all the statutes that have passed across the country.
Okay, so making sure this is what we call a classic language issue.
Yes.
It's the key word. The words, it means everything. So you're really financing. You're really a loan bank. You're loaning people money up front and expect to get paid back once the case settles.
Well, we don't consider a loan because with a loan, there's a guaranteed some certain repayment, meaning that if I give you $1 today, no matter what happens, I'm getting my $1 back. And if I don't get my $1 back, I can do something negative to you. The only way we get paid back on the contract is if the consumer is successful in their claim, and then secondarily, if there's enough funds left over. So after attorney's fees, medical liens, statutory liens, then we get paid. If there's not enough money to make that obligation, we don't get paid. And also, in the rare occasion, and it does happen, where the consumer drops the claim. So let's say they go to their attorney and say, hey, where are we with this? And the attorney says, well, we've got a good case, but we're looking at another 12, 18 months on this. And it's like, I'm tired of the snow, I'm moving to Florida, and drops the case. There's nothing we can do. We're just out that money. The only way we can go after a consumer is if there's fraud involved. And because we have the attorney sign off the transaction, their attorney would have to be involved with it. And I really don't know many attorneys who are willing to lose their law license over $3,000 that someone else got.
So it's like mortgage insurance that you're covering.
It's more. I mean, if you had to akin it to something, it's more of a speculation, for lack of a better term. We're saying, yeah, okay, there's a good probability you're going to be successful in your case. And if you're successful, we get paid. But if you're unsuccessful, we don't. And about 10% of the time, our companies get absolutely zero back. And about 30 to 35% of the time, we get less than contracted amount back. So it is a very high risk business.
Okay, Representative Kipps.
Thank you, Mr. Chair, and thank you for coming to testify this morning. This bill deals with litigation funding, and you've specified that litigation funding and consumer legal funding are totally different. Does this bill that's before us today deal with consumer legal funding in any way?
Yeah, and it does in the general form, and then also specifically also in the new amendment. It clearly defines better, we think, the differences between the two, but it does regulate both the consumer side and the commercial litigation financing side. It does regulate both entities.
So you're in this language here is what
Yes.
you is what you want.
Right. That and the major amendment.
And it-
Yes.
What do you mean by major amendment? This is. Okay, but this is the amendment that you're talking about.
Yes.
But in terms of the regular bill, but that just
Right.
adding this paragraph.
Right. Yeah. I'm referring to
Adding this paragraph to the
2025-03218.
Okay.
It was where we're in support of.
Oh, I have 294 F5 and then F7. Am I missing another page or something here? Okay.
Yeah.
All right,
Yes.
Representative Ammon.
Thank you, Mr. Chair. Thank you for your testimony. Just to help me better understand your industry, you have a contract, it goes to a potential client or partner. Their attorney reads the contract.
Correct.
What's your relationship with their attorney?
It's
Do they-
basic.
Are they part of the contract? Do they sign off and?
They just basically acknowledge it because we want to make sure that the attorney is fully involved and fully knowledgeable of it, because it's actually the attorney who repays the company out of the consumer's trust account. So when basically an insurance claim comes in and gets paid, it goes to the consumer's attorney, goes to their trust account, and then the attorney is the one who cuts the checks. They cut a check to themselves, to any other medical liens or whatever it is, and then they cut a check to us. So we want to make sure they're fully aware of these transactions right from the get-go.
Just quick follow-up.
Further question, may inquire.
So the attorney doesn't have any contractual relationship with you?
No.
But they benefit by approving the contract, right? So if they say, yes, I advise you to sign this, they're getting a cut of the proceed, the potential windfall.
No, well, no, they get their money out of the settlement, not from us. And we're clear in the statute, there can be no quid pro quo between the funding companies and the attorneys. So there's nothing going between us. They only get paid out of the settlement as well.
All right, thank you.
So are you in this bill now? In other words, are you required under this bill to report
Yes,
your transaction?
correct.
So you a part of the, okay.
Yes.
The fair, all right, great. Any other questions to committee members? Seeing none, thank you very much.
Thank you for your time.
Okay, Nathan Fennessy from AIG. Yeah.
Morning, Chairman, members of the committee. Nathan Fennessy, I'm an attorney at Pretty Flaherty here in Concord. I represent AIG. When I'm not up here spending time with you, I defend and litigate cases. So I want to speak to really just the disclosure piece of this, which is why AIG supports this bill. For years in New Hampshire, defendants in litigation have had to disclose information about their potential insurance policies that could apply, including policy limits. What we're looking for here is what I would say reciprocal transparency, which is if either a consumer or a business is getting some funding for their litigation, that they simply disclose that information so that everybody understands who has a potential interest in the litigation, who has control over the litigation. We think that's a fair thing to do for both sides. With respect to, there's a lot in the bill. I won't speak to all of the various provisions in the bill, but we do think there's some common sense regulations within it, such as making sure that a contract's filled out before the consumer actually signs it. That to us just seems like common sense, so everybody understands what they're getting into. So that's all I have. Everybody else has, I think, covered most of what you need. Thank you.
Well, jog my memory because I know this was last year, but the issue didn't come to Commerce. So we did pass the statute where no, I didn't think it passed.
So,
It failed.
under
So
the
you imply that it did pass, that you have the disclose the.
So under court rules, you have to. So I do want to address one point. So under court rules, there is an obligation under the mandatory disclosure obligations for insurance companies to disclose information. That is in the court rules. It's Rule 22.
So that if the judge deems it
Nope.
appropriate.
Nope.
So what was the
that's-
purpose of the bill we passed last
So
year?
last year's bill was trying to force insurance companies, before there was any litigation, to give information over to plaintiffs' attorneys. That was the intent of that bill.
Right. That one failed.
It did not. It did
Okay.
not pass. So
And-
I did just want to address that one issue, because what I think I heard from the trial bar was, well, if you want this information, you can just ask for it. Well, I can tell you in other states, when people have asked for it, they've opposed that and taken the position that this is confidential, it's not relevant, you're not entitled to any of this information, it doesn't impact any claim or defense. And so that's why these other states have moved forward with some sort of a disclosure statute, because doing it in the context of litigation leaves it up to an individual basis for a judge to determine whether or not this information can be shared.
Got it. All right. Thank you very much.
Thank you.
Chris, you want to say anything?
I think Chris Nicolopoulos, representing the National Association of Mutual Insurance Companies, I've provided you written testimony. We support this bill. We're happy to work on any of the amendments. I think Rep. Spears might be right that reference to governor may actually supposed to be president and
President.
Department of State. These are people that have been characterized as foreign actors, and so I think it's right that might be a typo, but we're happy to work on that. I think this is
As the president of the United States is supposed to weigh in.
no. These are folks that have already been adjudicated as foreign actors.
Have already been identified as.
It's referencing a federal regulation for foreign actors that have already been listed
Okay.
as actors.
Gotcha. Okay.
But otherwise, this is a great bill. I think ensuring that consumers understand what they're filling out before they enter into these arrangements is important, and the disclosure is going to make the whole litigation process better. I don't need to say more than that.
Great. Thank you. Jim, do you want to represent Jim Hayden from State Farm? And we'll wrap it up for us.
I will wrap it up in as quickly as humanly possible. So, members of the
You're
committee,
not going to take 10 minutes.
I will take no more than 5.5. So, members of the committee, Jim Hatem, here on behalf of State Farm, one of our state's largest writer of homeowners and auto insurance, and I am here to testify in support of HB 733. And I understand there's an amendment floating around, and I'm happy to work with the committee on that amendment. I think that, State Farm's support of this bill is really focuses on the fact that this litigation financing is a big business. It's here to stay, and it certainly helps folks in New Hampshire with their litigation and their litigation expenses that hopefully ultimately will promote justice. The concern we have is it comes at a high cost. And we think it's in everybody's interest to make sure those high costs are front and center for anybody who's considering taking out litigation financing. The high cost comes in the form of legal fees, interest fees and other charges that go into the lending. And this bill would make sure that those legal fees, financing fees and interest are front and center, so that when an attorney is talking to their client about taking out some litigation financing, it's obvious to everybody what the cost is going to be. And when it's referenced that this business operates in the shadows, part of the shadows are the fact that we in New Hampshire don't have a lot of experience with this. And attorneys aren't really well equipped to inform their clients about how much they might be able to get from, or how much an alternative premium litigation financer might cost. So by disclosure and getting that information front and center, it's going to make it a whole lot easier for the attorney who's advising their client about litigation financing, how much it's going to cost them in the long term. But it's also important that the consumers and the plaintiffs here understand the cost of involving a third-party lender in litigation. Basically, you're introducing someone who has no interest in justice and is frankly looking to make sure they get a return on their investment, right? So they certainly want to know what your case looks like. They want to know all of the details, and they want to basically put themselves in the middle of a litigation decision and discussion between an attorney and client. And that is understandable, but a necessary part of their willingness to lend against the potential settlement or return. And that plays out in the inception of the case, where it's a question of confidential information and strategies, but it's also involved in potential settlements, because the lender is going to have an opinion about how fast and how much a settlement might be. And so, they're really bringing someone into a business relationship that is really going to have an important say in that. I think it's clear that when you take away the financial impact of a litigation and sort of pass that risk off to a third party, it is necessarily going to have an impact on the willingness of plaintiffs and lawyers to bring cases. And there's a lot of thought out there that says this will promote frivolous litigation and prolong lawsuits. And I think that's hard for folks to ignore. And, I think when the discussion about secrecy and, about operating in the shadows, again, currently we don't have a lot of litigation financing going on in New Hampshire, but it is going on. We don't know really who's doing it. We really don't know the terms they're offering. And certainly by having them register, you're really asking them to register to do business the way we ask every other business to basically put their name down in their contact information with the Secretary of State's office, so that if someone has an issue with this company, they know who to talk to. So with that, I would want to touch on one point that was made about enforcement. And there's a pretty powerful enforcement mechanism built into the bill. And that is, if you violate the statute, the contract is null and void, which basically means the lender is not going to get their money back. So you have a really powerful incentive for the responsible companies that are willing to come to New Hampshire and abide by our rules to, in effect, abide by those laws, because the consequences of not abiding by our laws are simply they're not going to ever get their money back. So with that, I would say I'm happy to take any questions, and I'm happy to work with the subcommittee on any amendment.
Representative Hammond.
Thank you for allowing me to ask a question. I'm trying to understand, you represent State Farm. You're probably involved in a lot of litigation over auto accidents, I'm guessing, or maybe even, let's focus on auto accidents. What's your relationship with these companies? Do they bolster the client's ability to litigate against your claim sometimes, or do you partner with them in other times so that you share the risk with that company for whatever the damages might be? What's State Farm's relationship, typical relationship with these types of companies?
So State Farm does not itself have any direct relationship with any of these companies, and it very frequently sees them on the other side of, involved in lawsuits that they're involved in. When you think of where this might come into play, there's, and I forget the terminology, there's lending in advance to a plaintiff who, is basically looking to get their money faster when they have a lawsuit, okay? But there's also lenders who will, in effect, finance the litigation costs for a whole sort of broad range of lawsuits like auto accidents in order to, in effect, finance the acts of the the legal representation of plaintiffs' lawyers. So that's where it comes into play, more with relation to State Farm. And lastly, we see a lot of this involved in class action lawsuits. And there's plenty of examples out there for those big cases.
Okay. So, are you suggesting then, when it came to the violation section, we don't need paragraph little b at all? Just get rid of that and just stick with they lose their right to get any money out of the case.
So I don't have an opinion on that right now, but as I saw the committee wrestling with the idea of enforcement, I think it's important to note that's in there.
Could be waived.
Yeah,
Okay.
and-
But you're emphasizing A is already there.
Right.
But you're not necessarily saying let's take B out, but that if we did take B out, that would certainly clean up the problem.
Yeah, and I also saw the commissioner and as well as
So this is what you believe. I'm sitting here thinking that if they're trying to settle a case, and the attorneys who are defending are saying, "Boy, we want to make an offer to the other side and get them to take this offer and settle the case, so we don't have to go to court or something." Having the information about what the liabilities that defendant has and all the kind of contracts that they have out there, wouldn't that be helpful in the sense that then you need to make an offer good enough so that they still get something out of it after they've taken care of all those problems? Would you believe that might actually be a useful way to settle a case if both parties know, if the other party knows what they're in for?
Yeah, Mr. Chairman, I would say I not only believe it, I've also been through the discussions with the trial lawyers about when they should have access to certain information relating to policyholders. And I understand the dynamic, I understand the tension, and I'm certainly willing to sort of discuss how to sort of just balance that if this committee wants to go in that direction.
Oh, balance. Oh, I like that. Thank you.
I'm here to please.
Well, and on that happy note, I will close the public hearing. Yeah. Okay, let's everyone take their seats and the peanut gallery get their seats. Okay, so this morning it's a little lighter because we will not have 678, which is the over the counter, because that bill has officially been withdrawn. And so we will not be taking that up. So we're really now down to 499, making technical corrections to certain insurance laws. And we just had an amendment passed out to everyone. Hopefully you have it in front of you. It has my name and it's amendment number 0364. And can I have someone from the, oh, DJ, you're here. You want to just explain what we're doing here? And
Thank you, Mr. Chairman. Joining me at the table is Jennifer Smith, our legislative director. So this amendment is seeking to clean up a couple of housekeeping items that came up following our signing off on what I've nicknamed to be our technical bill. My understanding is there is broad consensus around these changes. I don't believe there is any controversy, but we can certainly answer any questions you have.
so in terms of what was in the original bill, what's in this amendment, why, just give us the highlights of the
Sure.
change.
So I think the first part of it, Mr. Chairman, was something that you had raised in terms of, I'm sorry? The carriers had raised it, pardon me. So I think the statute originally said 800,000. So just to back up for a second. I'm all confused. Hold on a minute. Right. So we clarified that this is only applying to new companies coming in. Again, the problem we were trying to solve was the sometimes flood of interest to form and domesticate a new insurance company in New Hampshire.
Fly-by-nights thought it was
Exactly.
the low number was too appealing to
Exactly.
choose New Hampshire to create this scandalous entity.
And so our team was just having to kick those things back left and right. So we wanted to raise the threshold to get people who are a little bit more serious about actually doing good insurance work in the state of New Hampshire. So that is where the language that you see here comes from. The number that we had originally set, as I said to you, I wanted to make sure that we had a number that was not serving as a deterrent to new players that wanted to enter the market. So we picked a number that our team thought met that criteria.
So this
Industry came
this
back and
company is
said-
going to be a domestic.
That's right.
Right. So we don't want it to be too high because we don't want people to be scared of New Hampshire.
That's right.
We want to be attractive. So with 3 million, are we still competitive? I mean,
Absolutely.
is there any
That's in line.
state out there that's any lower than us? Are we like,
No, that's in line with most other states, Mr. Chairman.
okay, good.
All right, so that was that one.
That's
Jen, do you want to hit the next one?
Sure. So the next, for lines 23, that section, so 23 through 27, those two changes are relative to the producer's fee section that's in the technical bill. Those were just some cleanup items that didn't carry over when we were making that first amendment. So that's just a couple cleanup things on those two pieces there.
okay. So we're adding this $25. Is it? Because
Yeah, I think
if it's
that's-
amending that, we're now adding we're adding the $25.
Yeah, and it has always been a $25 fee. I just didn't carry over into the bill.
Oh,
correctly.
so it got deleted, or
Yeah, it
the
wasn't-
fee got deleted?
It
and-
wasn't carried over by Scribner's note errors. so
Okay.
those are-
All right. Good.
We are still preserving the elimination of a number
All
of
the other
fees.
ones,
Yeah.
right? Right.
Yeah.
I know there was a lot of them.
And I would note, Mr. Chairman, that I found myself in a very awkward place of being a bit ahead of my time, in the sense that we identified those fees as being inefficient and not a good use of staff time and an annoyance to
I'm
industry.
sure the governor will be very pleased with you.
Well, I
and
was just going to say, and then the
renominate you
governor,
because
the governor put
had that foresight.
Yep, the governor
Okay.
put Code forward, and this was Roman numeral 1 on my
Good.
memo about
Yeah.
what we're going to do to help with that cause.
Perfect.
Go ahead, Jen.
Okay, and then the next amendment on page, the next change, excuse me, on page 1, line 31. In the original text of the bill that we put forward, it was addressing our network adequacy reporting requirement. in the original version of the bill, we had struck that requirement completely, but we wanted to amend it so that it was known that this information was still available and could be publicly available to everybody. So we just
Well, yeah.
amended it. So instead of getting rid of it outright, just making it more of a notification, it's available if folks want it.
Perfect.
Mr. Chairman, if I might, while I have you all, this is going to be something that you'll see a lot more of, I suspect, next year. Again, as part of the COGE process, we've gone through and analyzed all of the areas within the insurance statute where we have some sort of reporting requirement. We're trying to determine whether or not they're still necessary. And by necessary, I mean, are they just checking a box that they're in compliance? Rather than if we learn that a company is not in compliance via our consumer division or our enforcement division, I can then request them to produce the document that tells me where they're at, rather than having all sorts of reporting requirements that are a burden to industry and oftentimes do not get the appropriate level of follow-up from the department because we're just buried in them. So we're going to be going through all of those over the course of this year and coming back to you probably with a number of these, again, to try to not only be efficient for industry and not a cost burden to industry, but also ensuring that we are making the best use of our staff's time.
Right, so it's a reasonable way to make sure we have network adequacy without making
Yes,
a lot of
in
bureaucracy.
that particular case, that's exactly right.
Okay.
And we're in the process of updating our network adequacy rules right now at the department, so that's where this came up from, where those
Right.
are ready to be filed with JLCAR.
Well, I know the mental health was
yeah.
mission number one.
Yeah. So, so more might come that way from the network adequacy as that rule works forward.
Great.
So the next section so on page 2, line 5, this is relative to the law that passed last year, SB 173, the No Surprises Law. So these are just changes to, small changes to the law. We, again, over the summer after the bill was signed and put into law, we started our rulemaking process on that bill. And as we were writing our rules and drafting those, it became clear that we needed these small tweaks to the statute to really represent what we're trying to do in the bill itself.
Do you have to go back to rulemaking, or did you actually already?
We're in the
change
process of it
rules?
right now.
The rules are written and being filed with JLCAR.
Right, we just like chicken the egg, which comes first. right?
Exactly.
So put simply, Mr. Chairman, as you know, the intent of the bill last year as it pertained to Balanced Billing and No Surprises Act was to mirror the federal law. We missed a couple of provisions there to make it mirror exactly as we intended, so we fixed that there.
Great.
And this is the consumer warranty. We could probably do this.
So when we moved forward, again, I think it was last year with the enhanced protections around consumer guarantee contracts, we scooped in manufacturer service contracts on the manufacturer's products that had not been included in that before. It was included in one section, but not the other. We've determined that they should not be under that. So we're just cleaning up that provision that makes it clear they're going back to how the regulatory environment was for them prior to the big enhancement bill last year. So again, that's a technical correction.
Well, so who is responsible for those service contracts?
Keith, who's responsible for the manufacturer warranty stuff? They're still subject to the unfair trade practices statute, I can tell you that. So there's not complete, free reign there. We still have some oversight there.
Right, but we get a lot of complaints, right? There are people who buy these extended warranties and say,
So this applies to, what we're talking about are manufacturer service contracts. We do not get a lot of complaints about those.
manufacturers contract, service contracts to, who's buying these manufactured who's?
I'm sorry, Mr. Chairman?
So let's take a John Deere.
Mhm.
We had complaints about John Deere. So John Deere has a service contract with a third party? Or this is their service contract on their products, and who's taking advantage of this?
So under that scenario, that would fall under the Attorney General's office.
That would be under consumer protection anyways.
Them.
Okay, so so give me.
That's right.
Give me one that I know that we're basically taking things that normally would have been under the Consumer Protection Act and taking it out of your statute.
That's right.
Well, and this is a bit of a cleanup too, Mr. Chairman. If you'll notice, the numbering is quite off when we issued
Yeah.
our bulletin
Like,
over the summer.
right.
It came to our attention, so it went 1, 2, 3, 4, 9. So
Okay.
everything else had been cleaned up, and then that kind of did not get cleaned up when the bill was enrolling. So it should be in the next
Public
section.
utilities on there, oh, public utilities. Okay,
And we did run this by, industry is the one that brought this to us as well
Right.
as when the bulletin went out. So we addressed it with industry and cleaned it up as they requested.
That's right. Attorney Hayden back there is very involved with those particular kinds of products. If you've got questions about how they work or how historically those products have been overseen, I think Jim's your guy. You can get him an extra hour. He can bill his client.
but he had cell phones, you know, the insurance products and cell phones. I mean,
You wouldn't
I'm
believe,
just worried-
you
I'm
wouldn't
worried about-
believe the number of times he turns up on something. You're like, you're involved with this too?
Okay, all right,
And I think that's it.
That's about
and
it.
that's just renumbering, okay. All right, any questions from the committee members?
Too many hearings today, Mr. Chairman. Sorry, that was a little choppy.
No, this is, we're in subcommittee, so there's no testifying. Okay, thank you very
Thank
much.
you very much.
Are we ready to take action? Now we need, yeah. Okay. So we need, so this is $4.99. See if we give you. You know, I'm not really crazy about this pre-numbering. But I guess it's good to make sure we don't forget somebody in the way of the process. But
Okay, so it's not executive though.
this is the subcommittee. Yeah, because you're the. But I thought that was what these were.
Maybe. Too much page.
Just think, by the time we get to the Senate bills, you'll have this down to a science. Don't even have it. Does it say- How about this one? Let's use this one.
Okay.
Because the bill got withdrawn.
Oh, okay.
So let's just use that. So you scratch. What's that?
Cleaning up.
Oh, jeez.
$4.99, and we're putting the amendment.
Okay, so what we're doing right here is, no, this is the executive session. We're doing that, okay? So just scratch that all out.
Yep.
And it's the technical, the title was Technical Corrections to Insurance Laws. Okay, and then we have the insurance department review of the amendment. And put Benton Gorton Smith
And Smith?
instead. And then you circle who's here on insurance. So whose insurance we got? Purcelli, Gibbs, Miles, Cole, Sharissa, Spear, and Hunt. So the only one missing is Burrows. Okay? Yeah. All right. So Representative Hunt, seconded by Representative Spear, moves ought to pass on amendment number 364H.
OTPA.
And it's OTPA on the amendment, ought to
Okay.
pass on the amendment, okay?
We're gonna do the amendment.
We do the amendment first. All right, any discussion on ought to pass on the amendment? Seeing none, all those in favor, please raise your hand. 1, 2, 3, 4, 5, 6, 7. Oh, or opposed? Representative Sharice, are you voting? You evidently are on the insurance subcommittee, right? Okay, are you voting for the amendment?
Yes.
Okay, 7-0. Okay, now Representative Hunt, seconded by Representative Spear. Moves ought to pass as amended. Okay, so now you're down to the next one.
Yep.
Okay. Ooh, yeah. And it's very confusing, isn't it? All right, you'll have to find out whether they're doing this right,
Okay.
or we're doing this right or not. Okay. All right, the motion is ought to pass as amended. Is there any discussion on the motion? Seeing none, all those in favor, please say aye. Aye. 1, 2, 3, 4, 5, 6, 7. Okay. Amendment adopted. All right, and you're done. Okay, 499 is done, and on to execing. All right, next up is 552, relative to coverage of children under state retirees insurance plan. 552. I believe we had no problems with this bill, right?
No cost to the state.
Right.
Yeah, actually, I have a question on that.
Okay, sure.
The subcommittee, so I can ask questions internally, right?
In subcommittees, this is very relaxed, where it's a conversation. Yeah.
So the question is that, it's good that you don't require them to be a student under 25, but
Right.
But I also read that there's no calculable impact on the financial burden based if you include everything.
Right.
Have you done a study how much and who is going to take care of the additional? Does this bill?
Yeah, this is under their entire retiree plan, so there is no fiscal impact to the state. Because we've as long as we fully fund our retirement plan, as long as the retirement plan is fully funded. So what happened is in this case, and when we talk about some of these health insurance mandates that we passed in the committee, how it only affects a small group of people, or only affects the small businesses and the individuals, and their insurance companies, will then have to raise the premium to make up for that mandate. But when we passed that years ago, this was even before the Affordable Care Act, we had passed it, okay, that obviously there were some people who weren't included, and that was the state employees. Then what now became obvious was, well, not just the state employees, but what happens if the state employee has retired? And they're getting their benefits, from this retirement fund. Their kids get, still have the benefit. They shouldn't lose it just because they retired, and so that's why it's a minimal cost, because we're talking very, very few people involved. I think there was only like 26 or something.
So where?
Right, the parent.
Actually has to pay for the student to be in that.
Right, has to pay.
It's not that it comes out of the pension.
Oh, they're actually. Oh, okay. I missed that part. I forgot about that. Okay, I don't have it in front of me. Nobody's here. Okay, Representative Miles.
Wasn't the other aspect that they could be covered without being a student?
Well, that's the key element of the 26-year-old, right? Because in the way back when we first addressed this issue, and this was before, like I say, it's before Affordable Care Act. So we passed this a long time. I would say I was not in the chair at the time. This was when I was on my sabbatical, and the issue was that we always required that you had to be a full-time student to be able to get the benefit, and it's good. It's just fairness, It's a fairness issue that everyone else is getting the benefit because under the Affordable Care Act it was mandated. So it's just the nature of their insurance product is being under this retirement plan. It just never got picked up and never got allowable.
So kids in general on other plans don't have to do this anymore?
That's correct.
Okay.
And that's been like 20 years now. Exactly.
That's under the Affordable Care Act. That is how it is.
It
right now.
eventually, well, the Affordable Care Act certainly picked up more people. The Affordable Care Act got the ERISAs, okay, but that again, it never. This retirement plan is a very unique product that was exempt from all regulations, so it never got picked up.
Oh, so as of now, the retirement plan basically, if they're not students, they will not be covered. Is it
So
like that?
if they're a student, it doesn't matter whether they're a student or not. They can get the coverage until they're 26. And that makes it the same for everybody else in the country.
That's what this bill
That's what
talks
this bill
about.
does. Yes.
So as of now, it's not happening.
It right at the moment it is not happening. That's why we need to pass this bill. That's why we want to vote ought to pass so they can get the benefit.
Chairman?
You got it? Because I know you got confused that last time. So
Yeah, I got that part. The only thing is that I'm still not clear is that the retirement benefit plan that we're talking about, this is the employer.
the employer is the state.
So
State of
they
New
are the one
Hampshire.
funding it. It's not.
They got left out. But it turns out you're saying is it still has money. It's still the bill way it
It
reads.
says in the fiscal note, it says, however, the cost of a dependent's coverage on the retiree plan is $1,044 per month for a non-Medicare eligible dependent paid entirely by the retiree to the plan.
Right.
Yeah, and the
So
next
as long
line
as you
also.
want to pay $1,000 a month,
You can
your
get the
kid covered.
benefit. Right. They get the coverage.
Okay, and the next line also I had a question that why it says expanding eligibility may increase enrollment and potentially increasing cost to the retirement benefit health benefit plan.
You're reading the fiscal note now.
Yeah, the
Okay,
next
so
line.
What does it say in the fiscal note? I know. What is he? He's asking something about that last phrase.
Well, the line that you read just now, next line, it says expanding eligibility may increase enrollment and claims, potentially increasing cost for the.
Potentially increasing costs for the retiree health benefit plan.
The
Okay.
retiree, because the retiree has to pay for that insurance plan for their kid.
Okay. So as long as so basically there's no obligation or burden to the.
After hearing this, I would say no one's going to take advantage of this because they can get health insurance cheaper for their kid.
Okay.
Under the marketplace, they could just sign them up individually as an individual, and they wouldn't have to do it. So this is
Okay.
feel-good legislation. Because, well, I mean, they'd say this is an opportunity for somebody who might want to have their kids on the plan. Kids are really cheap. Younger, it's well, the way there's an age band, okay, and the age band is 4 to 1. So right now, I would, in terms of my employee who's really up there, so it's like $1,500 a person. So divide that by 4. Now you're down to 400.
Karen, please talk at the mic.
Oh, really?
So.
Okay.
So basically, if I understand it correct, including this is not going to increase the burden on the insurance company or to anybody else except the person who is enrolled in that, and they are going to bear the cost.
Bingo. You
Okay.
got it.
Well, that's a no-brainer then.
Yes, that's absolutely correct.
Thank you for explaining.
Right. Okay. Is somebody else? Did I sponsor this bill, or who? Did somebody else sponsor this bill? Who's the sponsor? Okay. Who? Anybody would like to write the blurb on this one when we take it up?
So,
Okay.
so can I ask you one quick curious question? If this was this much, easy and no-brainer, so why this was not even brought up for the last 15, 20 years? It was just neglected.
Because life is like that.
I guess I have to play the tape and see what the sponsor said and how all of a sudden they became attention. Did anybody remember the hearing? You take good notes, John. What did she say in the hearing?
There wasn't much on this one.
There was no discussion.
Luno is the only one that spoke. No cost to the state. That's the only,
So the sponsor wasn't even here?
right.
Okay. I guess.
They don't give a crap about it.
Ours is not to ask why. Ours
They
is to
they
do
forgot
and
about
die.
it. So okay. so long.
Leno.
many years.
Oh, that's right. Leno was here. Yeah. He was here. He was going on and on about how great a chairman I am. And that's all I remember. Right? That he was throwing praises towards me. Right. And of course, Senator Reardon is also a former member of the committee. So she was probably on the committee back when we passed it, way back when. Okay. All right. Right. So Representative Spear, you'll make this motion for me?
Sure. I'll
Okay.
make the
Representative
motion.
Spear, seconded by Representative Hunt, moves ought to pass as amended. Any discussion on the motion? Seeing none. all-
Wait a minute. What amendment?
No amendment. Ought to pass. Just ought to pass.
And Mrs. Hunt?
No, Spear.
Spear. Seconded by Petrusi?
Me.
I'm not on the committee. I'm just a hanger-on.
Okay. All right. So the motion is clear. All those in favor, please say aye.
Aye.
1, 2, 3, 4, 5, 6, 7. 7 zip. And on to exec. All right. 678's been withdrawn, so we're done for this morning. So this afternoon, all we have is the ambulances.
Yeah,
All three of them.
that's the
All
that's the
we have.
big that's a big elephant in the room.
So the room will be a little busier when we take up ambulances.
John, we're not doing 678?
As I said, this bill has been withdrawn.
I did not hear that.
You saw me, you came help me with a pen.
Look, you needed help?
Okay.
No question. I just do have.
Okay.
All right. Subcommittee this afternoon?
So the subcommittee is the ambulance bills. So that's it. Okay, so then I have done beginning my paperwork on for the next 2 week or 3 weeks, let's call it. So next week, I'm assuming that at this point we have not been able to get a smaller room, so we will have subcommittees down in 104. And I tell you what I am thinking. I have here. Okay, no, not yet. Okay, here we go. Yep.
I thought on 678, the last thing we had is she's going to come back in with an amendment. I guess
No,
nothing.
she then, without
killed it.
discussing it with me or anybody, she just ran down to the clerk's office and
took it
asked to
out.
have it withdrawn.
Okay.
But to be honest, is I explained to her the problematic issue is the enforcement. And they lifted the statute from, I guess, New York and they were Massachusetts, but other states, their attorney general's office of the states, district attorneys, they're the ones who handle the consumer protection laws. Okay. And so they could treat it a consumer protection issue. So, and I said, well, where's the enforceability? Who's making sure that that's not getting sold? Oh, no, it's the same as we always say, the drop a dime. You need, the only time they would worry about it is if somebody called up and said, oh, by the way, that health food store was selling that. So once I explained to her that in New Hampshire, we don't do it that way, and that theoretically she would need to have the liquor. We need to put it under the liquor division, and because they're the only ones that are out there checking for aid, for selling to it. And I said that, but boy, is that going to be awkward.
Yeah.
And but it is not so bad given that pretty much every drugstore and grocer and convenience stores, because he was talking about convenience stores, all of them sell beer. And so therefore the Liquor Commission is already there. Is already doing the age enforcement. So the only people that's gonna be problematic is let's say someone did a pop-up thing in the mall. Well, we've done that too at the Liquor Commission because they do the vaping. There's those
Right,
pop-up
right,
vaping stations. So I said that's not so bad. So it's not totally. It would just be a little awkward for and.
But the other problem that was wrong with the bill that I felt also, not that it makes any difference at this point, is that it was very broad. Some of the things that were listed there were legitimate vitamins and minerals and things like that, that, you know,
And I said to her, I said, so let me get this straight. So the FDA doesn't regulate any of these things that you want to be worried about whether they're over 18, Vi? How the heck are we going to, rationalize that enforcement?
I couldn't see it.
Exactly. So instead of us killing it, she was afraid that that means she couldn't bring it back next year. So by withdrawing it, she can come back with something next year.
So procedurally, could we have retained it?
Oh well, that's what I told her I do.
Yeah,
I said,
right.
I always said to her that out of we would, this
But she didn't want to?
our reputation. I don't know how you do it on your other committees, but in our committee is we understand that you're in a pickle, and that this is you're going to do a lot of have to figure out how you want to do this and how you're going to spin it. That you could retain it, and we'll take it up in September and see what you got. The amendment that
She
you
didn't
got.
want to do that?
She had already had gone to House Clerk to have it withdrawn, and
Okay, then.
of course my conversation with her, John, is this something we voted for? Oh yeah, we've all voted for this. And I go, I don't know, but it's obviously for me it's we've never had this withdrawal process, but to me once a bill has been introduced, and certainly after we've had the hearing. That bill belongs to this committee. It doesn't belong to the sponsor.
But we didn't have the hearing.
We did have the hearing, didn't we?
No, we didn't.
Yes, we did.
No, the first thing she said, no, she was here, and the first thing she said, I want to withdraw this bill. That was the only thing that was ever
That's a
said.
different bill, but.
No, it was this bill.
It was this bill. And she said she wanted to withdraw it?
That was all that was said.
No, I'm saying it was Newsom. We had Newsom and Leno.
Say again, please?
Newsom and Leno were the ones that came in and spoke for it.
That's it. I have it on my video. I typed it up last night. So.
Really?
If she's withdrawing it, it doesn't matter all that much when she withdrew it.
Yeah, that is absolutely true, Representative. Okay, so I was just saying, so in terms of next Tuesday, next week, so I think in the morning I'll be doing the business plans, business bills, and the insurance subcommittee. This won't meet again until March 4th. The subcommittee.
Subcommittee for 3:50 and 3:35.
Okay.
Can you do business on Wednesday and not Tuesday?
Wednesday is we have the whole committee room, so I want to. Technically we're not supposed to be allowed to go on vacation unless we have got our business caught up, and so I was planning on Wednesday the 19th to hear the remaining 8 bills that we have, and get it done. So that means when we go on vacation, on beginning the 21st, we will have heard all our bills and had subcommittee, at least one subcommittee on all the bills that need to be done exec on, and this is the important date for everybody, Wednesday the 5th. Because Wednesday the 5th is our exec session for the 13 bills that we have to be out on the 6th. Okay, so, but I did schedule for Tuesday the 4th, again, because we have a smaller committee room, the March 4th, that Tuesday the 4th is the health insurance bills that are, have to be out, have to be voted on by the 5th. Now, just to be, honest and frank, if we get into that 4th and things are not going well, I mean, in terms of the glucose bill, for instance, if we're not going to be happy with what we're doing, if anything, if we have the opiates, whether the sponsor, I got an email, when I sent him the amendment, and he says he wants to talk to me about it because he doesn't know what we're doing, at least though we can't read the bill or something, I don't know, but he wants to talk about it. So if any of these bills go south on the 4th, that we can't agree to something, well, yeah, on the 5th, we'll just retain it.
So why do you want to? Sure.
Yes.
What is it that we're doing on the 18th?
On the
That's what my question was.
18th is going to be a subcommittee, and that subcommittee will be liquor, and business bills. So
Thank you. I'll
this-
be in the Housing Committee that day.
Right. So this subcommittee, the insurance will not meet until the 4th.
Thank you.
The 4th is a Tuesday. And you do have housing on Tuesday. It is what it is. So, I mean, in terms of, I don't know what will they be doing on that day? Do you know what they're doing on that day? Are they doing hearings? Or are they doing execing? Or what are they doing? Yeah. Okay. So, but you have your vice chair here, and I know you're on it, and Representative, the three of you. So we could certainly, in terms of the issues of what those bills are, we will figure something out because it's just a subcommittee, so we can be flex if you guys are suddenly into an exec session and that. So let's say in the order of priorities, you're execing. If you exec anything on the 4th, that's the higher priority. So that we will accommodate you not to be in commerce. Okay, but if you're just doing a hearing, then you can come on down. Is that okay?
That's fine.
All right.
And we'll know.
And you'll feel what happened.
And I'll let you know.
Yeah. But otherwise, Wednesday the 5th is D-Day for executing all 13 bills that we have to have out of committee.
That's right.
Okay.
Will you keep track of who's going to be writing blurbs? Because I remember that worked out well when you sent out a list of this person is writing. and this person-
I will. That's what I'm doing now, so that when we because my intention is, as usual, that by we get to the 5th, we'll already know what action we're going to take, and I'll have who's going to make the motion and who needs to have the blurb, and they need to get the blurb done that day. Because the 6th is the 6th is the deadline, but they scheduled a session on the deadline day. Please don't ask me. That's just. My mission is not to ask why, it's to do and die. All right. See you all later.
We have a session on Thursday next week.
So,